3 minutes. Namshivaya, Salma ma'am, Namshivaya. Salma ma'am, can you hear me?
Yes, I can hear you.
Okay. Shashangan sir is here, Salma ma'am. And Sunita is also here.
Hello.
Om Namah Shivaya, Salma.
Namaskar, Salma.
Namashivaya.
Shashank, at the moment only the presenters can hear what we are talking. 6 of us.
Yeah, there are only 6 of us as presenters. The others are attendees only. So 100 plus attendees are.
Okay, so I mean, we may have to have a heads up. The schedule is slightly shifted.
Yeah, I'll just do that, sir. I'm just doing it. Just I'll start the prayer. In a minute, we'll start, sir. Just a minute.
Just informing the presenters that there
Yeah.
is a slight shift in the schedule.
Sure.
I'll be going first. So because I have a prior commitment and I have to leave. So
Yeah. Okay. Om Namah Shivaya. Very good morning to all of you. A warm welcome for the this webinar on IPR and innovation, organized by the Patent Office of Amrita Vidyapeetham and the Internal Quality Assurance Cell of Amrita Vidyapeetham Coimbatore campus. Let's start the proceedings with a prayer.
Shri Gurubhyo Namaha Harihi Om Om Sahana Bhavatu Sahano Bhunaktu Sahavidyam Karavavahai Tejasvinavadhitamastu ma Vipvishavahai Om Shanti 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 Om असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्योर्मा अमृतं गमय ॐ शान्ति शान्ति शान्तिः ॐ सर्वेषां स्वस्तिर्भवतु सर्वेषां शान्तिर्भवतु सर्वेषां पूर्णं भवतु सर्वेषां मङ्गलं भवतु ॐ शान्ति शान्ति शान्तिः ॐ लोकाः समस्ताः सुखिनो भवन्तु लोकाः समस्ताः सुखिनो भवन्तु लोकाः समस्ताः सुखिनो भवन्तु ॐ शान्ति शान्ति शान्तिः ॐ पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते ॐ शान्ति शान्ति शान्तिः ॐ श्रीगुरुभ्यो नमः हरिः ॐ
For this webinar, extend a warm welcome to the various speakers, Ms. Sunita K. Sridharan, FSKS Law Associates, and our own faculty members, Dr. Satish Babu, and of course the person who conceptualized this seminar, Salma Jeta ma'am, who's the patent coordinator of Amrita Vidyapeetham. So just to give you an objective of this seminar and the the strategy for Amrita Vidyapeetham, the Coimbatore campus, I warmly invite our Dean of Engineering, Dr. Shashangan Ramanathan, to address the gathering. So we have just flipped his talk to the first, and after his talk, we will have Sunita ma'am speak about the IPR. Over to you, Shashangan sir.
Om Namah Shivaya. Am I audible, Prashant?
You're audible, sir. You're audible.
Okay. Om Namah Shivaya. Very warm welcome to everybody to this workshop on IPR and innovations. I want to thank Sunita, Salma, Satish Babu for participating and giving their insight into what IPR is all about and why innovation is important and how innovations can be turned into commercial products. What I thought was, first of all, I have to apologize that the schedule is kind of flipped, but based on my experience, I thought I would talk a little bit about what is commercialization of patents and intellectual property. Now, what is commercialization? It is about trying to either sell the patent that you have or license the patent. And basically, licensing means somebody's interested in the patent and they want to make a product out of it or use a patent in their existing product. Basically, turning patents into revenue. Now, many of you might be thinking, among the audience, you may have people with lots of patents, people who have few, and people who are yet to have any patent to their credit. Please understand that not all patents are commercial. It's not that easy. If you look at worldwide, what is the percentage of patents that are actually commercialized? It's probably in the range of about 9 to 10% maximum. Typically 5 to 7%. But that's okay. Eventually, all of these patents, if they're strong, they will find their way into commercial products. What I thought was I would share just some very high-level glimpses of what is commercialization, and I will share some slides with you because obviously every one of us likes to see something, not just be listening to people. So let me share a few slides with you, just to give you an oversight of what is commercialization. I'm sure the rest of the speakers today in this workshop will talk to you about many more things about patenting itself. So give me a second. Let me share my slide. Prashant, if you can just let me know if the screen is visible.
It's coming, sir. It's coming. Yeah, it's come, sir. You can put it in slide full show. Yeah.
So commercialization of intellectual property. I mean, simple questions are: what is intellectual property? What is patentable? And why should ideas be patented? How to file a patent? What are the benefits of patenting? I'm not going to talk about those 4 points because I'm sure the rest of the speakers would definitely address all of these points in a very detailed way. Now, what I would like to talk about, and I think they should set the goal and the motivation for all of the attendees to pay attention to what's being said in the subsequent sessions. How does the inventor benefit? Obviously, we all can file patents. The first question is, what is in it for me? Correct? So commercialization, that probably includes, I'm just giving you a very high level. It is, there might be more bullets, and I'm sure Sunita, Salma, they would probably add more to it. Basically, if you can turn a patent into revenue, that's the fundamental concept of commercialization, and the commercialization aspect can be a benefit to the individual inventors as well as the company or the entity that owns the patent. Now, patents, you can have licensing fee, royalty fee, incentive to the inventors, and sometimes you can even sell the patent. It's a one-time sale and you get the lump sum, and that patent is valuable for someone else. If I'm not going to Google it and tell you what it is, but I will tell you from my own personal experience on patenting and patent licensing. It's just a screenshot of what I have as patent in the last probably, I think my patenting thing started in 2000 and last one is about 2015. So in about 15 years, I've got 12 patents and probably another 3 applications still pending to be granted. So what do I do with these 12 patents? It takes time to write patents because you have come up with a concept and you think it's unique and you think it's valuable, and also you think it's going to be of use to somebody. Now, with all these things, you've written a patent and it takes time, and you go through a review process, you get back comments, and you have to defend why your concept is unique and why your claims are unique. So after you've gone through this process, you've got a patent granted. Now, what do I do with that? If I just take an example of all of these 12 patents, if I take one of the patents, this is issued in 2011. The owner is assignee. You see a little box there, it says Extron Inc. Now, the owner of the patent is Extron Inc., and there are a whole bunch of inventors. Now, the reason it's owned by Extron Inc. is because the invention was done using the resources of Extron Inc., which is a company in the USA. Now, what did Extron do with this patent? If I were to look at it, it says Extron used this patent in their product, which means it's commercialized. That is, they found the value of this patent and they've incorporated this patent into their product, which is in commercial use. And that is being commercialized. And what did they do is incentivize the inventors with $10,000 each. Now, that is only after they find that there is a use for this particular patent in their product. So they said, okay, thank you very much, inventors. Here is your inventor incentive, and that's $10,000. That's one way to look at it. Now I've got another patent again here. This patent is owned by a company called Sharp. All of you have seen TVs. We used to have Sharp TVs. Sharp, it's a great electronic giant in Japan, and co-owned by Virginia Tech Intellectual Properties, which is the intellectual wing of Virginia Tech, which is a university in the US. Now, this patent was commercialized to an equipment manufacturer. And what did the assignee, Sharp and Virginia Tech, get? And what did the inventors get? The inventors got $50,000 as licensing fee, which is a one-time upfront amount, plus 2% of revenue from product that the other equipment manufacturer who licensed this product, 2% of their revenue is paid out to the assignee and the inventors for 10 years. I'll tell you what happened. Basically, I didn't have to do much. After this patent was licensed to somebody, I got $50,000 upfront plus 2% of the revenue for the next 10 years. So I used to get a check every 6 months from this company who licensed this product. So it was just a revenue for me coming in, and that is because the patent was strong and was commercial. Okay. So that is another revenue. This is all through negotiation. There's another product patent I'll tell you. This is again issued in 2000, owned by the United States of America, the Army. Basically, the Army wanted to have some device for advanced communication, and the inventors there could deliver something that the Army could use. Now, the incentive that the inventors and the assignees got, basically assignee is the Army, so they didn't have to pay it themselves, but the inventors were paid $15,000 per year for the next 5 years. So you see different sort of commercialization, different sort of negotiation, and eventually the inventors making money. So the simple answer is, if you have a strong patent and eventually when it's commercialized, as an individual you get to gain, as a assignee, the owner of a patent also stands to gain. So that's the fundamental concept, and please don't think all the patents can be commercialized. However, a strong patent is always good to protect and have it patented because it is your idea. You have come up with something unique. I will also give you another patent, which is with the assignee. The owner of the patent is Novella Systems in San Jose. And this patent is currently dormant. Dormant in the sense, yes, the company owns it, but they have not found a credible use for it in commercial products. So it is just sitting there. However, if the company decides to go ahead and commercialize it at some point of time, which I believe will happen in the next 3-4 years, they would have to come back and incentivize the inventors. So that's another negotiation. So there are multiple facets to how somebody can commercialize their patents. But patenting is extremely important because, one, it shows the world that you as an individual, you have come up with something unique, something that is worth patenting. And eventually, if somebody can use it, that's a great benefit to you and to the end user. Now, there is another aspect to it. When you patent something, you're actually disclosing all the ideas and the design concept and whatnot with the patent. So there is another aspect to it where companies and some of the what you call trade secret or know-how, those are not patented because an individual company or an entity does not want to divulge anything about something that they don't want to divulge. So that's called know-how, and it's a trade secret, and they don't divulge it. Once you patent it, obviously you've shown everything, so people also can find work around your patent. So it is important that you keep adding amends to your patent. You may have come up with something today. If you found something that's new and different next day, or year after, you should go back and file another patent that sort of strengthens your original patent. So these are some processes, I'm sure, between Sunita, Salma, and Satish Babu, they would outline all of it. But my point was commercialization is a key aspect. And if you have invented and you have a patent with Amrita, similar deals and structures are in place. So I encourage everybody, if you think you've got something unique, file for a patent. And process is there, and Salma will go through it. Okay. With that, I thank you for attending this, and I hope everyone benefits from this workshop, a great initiative by IQAC. Once again, thank you, Salma, and thank you, Sunita. Thank you, Prashant, for inviting me to this workshop. Om Namah Shivaya.
Thank you, sir. Thank you very much, sir, for setting the stage. I think from an IQAC perspective, when we look at the numbers in terms of research papers, PhDs, funding, at least recent funding, this campus is doing exceedingly well. But at the same time, definitely there is a huge scope for improvement with respect to the patent. And that's what we want the support of the patent office under Salma ma'am to help us, ramp up the patent filings in this campus. So I invite Sunita ma'am to take over. Sunita ma'am, can you share the slide, ma'am?
Om Namah Shivaya. Can you hear me?
Yeah,
Yes,
ma'am. Yes, ma'am.
Yes. So good morning. It's a beautiful sunny day in Delhi. It's cold. So you were seeing me in super warm clothes. And it must be really warm where you are. But having said that, we will just quickly, capture the essence, because my topic today is an overview of IPR. And looking at IPR, we have to look at various intellectual property and what really has to be done with them. I shall not really be focusing only on patents. Unlike the last time, I will talk about patents because it's one of the intellectual property rights, and that's very, very important. But needless to say that you can also get loads of money from copyright. And I think one of the excellent examples are, the Harry Potter series, which earned loads of money, made the author a billionaire. So, but what is required is to be very alert to the intellectual property you have, identify which kind of intellectual property you have. If you can create an IP portfolio, that is extremely important. An IP portfolio would mean that in a particular product, you may have different aspects of it which you can protect. Like, for instance, if we are talking about a Coca-Cola as a drink, and I'm specifically talking about Coca-Cola, not only do you have the trade secret in the formula, but you also have the design protection in the shape of the bottle, which is iconic. And it has been so iconic that even after the design protection lapsed legally, we still have, it was so iconic that it actually ended up being a trademark. And a large number of countries, including India, amended the trademark laws to bring in shape marks, because shape marks are so, that they bring into mind that particular product and form goodwill in that particular product. And if somebody else is copying that shape mark, it could well be a dilution of the trademark itself. So over a period of time, many things get put together in an IP portfolio, including the trademark, the patent, of course, the most important. If you have the patent on it, if you don't have a patent on it, then it could be the trademark. It would be also protecting your trade secret. It could be a question of your, the designs that are there in it. And of course, if there is a plant variety protection which is involved in that, you may want to look at that as well. You would have recently heard about the Pepsi patent being, revoked by the patent office. It is not the Pepsi patent. It is Pepsi had a plant variety registration on potato, a particular variety of potato with which they were making Lay's, the chips the potato chips. And that registration was revoked by the Plant Variety Protection Office, that is the Registrar of Plant PVP, the Protection of Plant Varieties and Farmers' Rights. So the registrar of that really looked into the matter, and then seeing the requirements were fulfilled or not, because there are certain requirements for each of the intellectual property. If they're not fulfilled, then of course, even if the the IP is granted, it is open to revocation. But when we talk about IPR, why are we talking about it now is the question, because it has been in existence for many centuries. And many of the countries have looked at patent and copyright since, I think, the 1500s. But more importantly, in this time, can you just give me a second, just a minute? Sorry, there was a disturbance in the background. Yes, we were talking about Pepsi. So you would think that a company like Pepsi, which is more focused on their soft drinks, would have nothing to do with the plant variety, but there is, and that is part of their IP portfolio. So these are things that we have to consider when we are looking at, especially when we come to commercialization, because you would not want to commercialize one aspect of it, of your intellectual property, and forget about the other aspect of the same intellectual property or of the same product. So let me get into it, and just by way of preliminary example, because I would mostly be speaking to you directly, and you're welcome to ask questions as we go along. But the point is, some of the things are so conceptual, so I just thought I will prepare a few slides. I have one or two slides, which I can then share with you, and you can have a look at that. Please give me a moment.
It's coming, ma'am. You can put it on the slideshow, full slideshow.
Yes, just doing that. Sometimes this system becomes yes. So
it's come.
yeah. This is I've put slides together from various aspects where I have given presentations across the world, and I have put them together at one place because just to give you an idea of what we are looking at. So if you see, first of all, right at the bottom, I say SKS Law Associates C within a circle 2018. Would anyone be able to tell me what this is all about? Okay, since I don't hear from anyone, this has to, yes, was somebody saying something?
That company was registered in year 2118?
No, the C within a circle is a copyright symbol that this particular contents of this particular slide is original, created by SKS Law Associates. So actually SKS Law Associates is the owner. The author of this is Sunita K. Sridharan, that you can't see here, but it is owned by SKS Law Associates. So there's a distinction between who is the author and who is the owner. And this was created in 2018. And then we look at the period of protection for an organization is 60 years from the next year. So that is how it is computed, looked at. So the moment you see C within a circle, it's extremely important for you to be cautious. And I'm actually jumping the gun, but let's go this way because this is a screen and it is right there in front of us. Plagiarism is something which is extremely, looked down upon, dangerous because there is a criminal implication. It is in many countries, plagiarism is tantamount to jail. Is somebody asking a question? There is. Okay, right. So, moment you see a C within a circle, this is copyright protected. Don't copy it. You can reproduce it. Give credit to the person who has created it. Saying that it was created by, SKS Law Associates is the owner of this slide or so on and so forth, and then proceed. So crediting information is important. Another thing that you can do is take the contents, keep it aside, you read through the whole thing, rework it in your own language. An example of this would be the story of the Ramayana or the Mahabharata, and you can then create your own original work. Original work in copyright is not equivalent to novelty that you all are very familiar with. Novelty in patents is completely different from original work in copyright. So, if you write a Ramayana today in your own language without copying passages, but referring to passages from maybe, the Kamban Ramayana or the Tulsidas Ramayana, so on, then you can just credit it and then give your own explanation to it. But coming back to this slide, in this presentation, I'm not going to focus only on patents. What I'm going to look at is intellectual capital. What are intellectual assets? And which is very, very, very important, especially for universities who are publishing their works. And if they're publishing their works, they have to keep in mind that if there is a patent aspect, you have to first file the patent and then publish. If there is a design aspect, you have to first file for design application and then publish. So these are very, very important points to keep in mind, especially for universities where the entire environment in a university is such that we are constantly springboarding on ideas, innovations, discussions, and so on. And sometimes it can be detrimental if you're looking to seek an IPR later. So you may well want to publish something now because it is a need of the times. But once you've published it, then the question is, can you file for a patent application? Or if there's design element in it, can you file for a design protection? Those questions will arise later in time. And then you will find that even though you have an excellent invention in your hand, you have no protection. So balancing act is extremely important. And then I will also tell you about the intellectual property rights per se, because that's where the meat of the whole thing is, so to speak, the substance of the entire IPR culture, the commercialization, and so on. But a brief history would be very useful. As very, very brief, I'll just be telling you about it. And I'll tell you about the present situation. But there are just 2-3 slides to help you get a perspective of it, and then I will be speaking. Why are we doing all this? Well, for one thing, we are globalized. Therefore, once we are globalized, we have to look at a level playing field. You can't be in a level playing field if you don't know the rules of the game. And then you will find that there is stiff competition, everybody trying to be the first. And you will see how competitive it was during the pandemic. 2020 and 2021 opened the eyes of practically everyone to the competitive markets available in, the medical device sector, as well as the vaccine sector, as well as all the fields of technology around this vaccine, as well as the device sector. Hello.
Yeah, in between some I muted everybody, ma'am.
Okay. Now, why are we looking at just this? And the emergence of intellectual asset management is extremely important because we file a large number of patent applications because you have to be the first to file. We have mechanisms like Paris Convention or Patent Cooperation Treaty, and they allow you to, claim priority from the first application that has been filed in your country of choice, provided you file them within 12 months or the period designated by the particular treaty or the convention. But nevertheless, there is a race to the intellectual property office to file. But once you have done that, it is extremely important to see that you're not merely looking at paper intellectual properties because you're looking like papers. I mean, you have a lot of certificates. What do you do with them? Can you convert them into, monetize them, commercialize them? If you can't, then there is a trimming of the flab, and trimming of the flab is done in different ways. There are various means of doing it. Some of the universities which have patents or designs, they can, work with maybe another university to develop it further, or with a company to put it in the market, or better still, just give it out to people as a goodwill gesture to use it and gain goodwill. So this is what IBM had done in, I think, 2004 December. They put out some 500 family of patents and said that these are patents that we have. Anybody can use it free. There's no royalty on it. The only condition being that if you develop something out of it which can be commercialized, you will have to inform IBM, and they would have the first right to first choice, first option to refuse, the first option to refuse. So this was that was the only condition. That means for these 500 family of patents, IBM was actually paying the fees at the intellectual property offices around the world wherever they had been filed and granted. But they put it out for free, and it gained them a lot of revenue in later on when it just went on to other people using it. Like Red Hat used a lot of their inventions, and then of course they gained revenue from that when Red Hat really went ahead and commercialized them. Now, I will not touch on this because right now you're not looking at the IP portfolio, but I will come on this. The intellectual property that we talk about, patent and so on, they are a very, very, very small aspect of the intellectual know-how or the intellectual assets or the knowledge and the know-how. It's a very narrow aspect of it. And under this, if you look at this, the way the Venn diagram is, if you look at the centermost aspect of it, intellectual property, under this, again, it is narrowed down with each of the intellectual property being identified with the kind of criteria that would make it either patentable or copyrightable or, geographical indications, registration of geographical indications. So each one of them becomes very, very narrow. Each of the intellectual property has their own law. So as you all well know, if you're looking at India, you're looking at patents, then it is governed by the Patents Act 1970, the rules and the amendments thereunder. Similarly, if you're looking at design protection, you're looking at the Design Act of 2000, the rules, and whatever notifications are thereunder. So becomes extremely narrow. However, if you see intellectual assets, which is that orange circle there, it is all the thought processes that you have, your creative ideas, the little scribblings in your notebook, the jotting down of a particular algorithm or a formula, and so on and so forth. They become very, very valuable at a particular time. But these are assets, they're not property, because there is no act of the government of India or any other government protecting it. There is no criteria made. You don't have to pay fees to the government. You don't have to pay annuity fees, and so on and so forth. This is information you created. Some of it is confidential. Some of it is a trade secret, and we will come to what is the distinction between confidential information and trade secret. And know-how is the know-how which is there everywhere, whether it's in a textbook, in a magazine, in a journal, wherever you come across it, in the workshop systems, when you go to a workshop and you watch the mechanic doing it in a particular way, he's broken out the entire process using his own systems analysis and design to figure out how he will manage. Even if it is a case of, you go to a bakery and you see how they put together the dough and how they put together a pastry. There is a certain methodology that goes there. There is a know-how which goes there, and it is there everywhere. Now, coming to specifics. Right now, we are talking about intellectual property rights, and we say patent, trademark, copyright, trade dress, trade secret, plant variety, GI, biodiversity. But this is just on various products and processes, semiconductor layout, design protection. But the fact of the matter is you need to then take out from this particular, this kind of noise, if I may call it noise, this kind of noise, and then identify very clearly what comes under what and why is it protectable. For instance, I have a trademark, trade secret, trade dress, copyright, and design. If I look at trademark and trade dress, could anybody tell me what is a trade dress? Any example?
Some uniform like thing, like crew members, they wear some particular uniform. Maybe some in a
That's
food
right.
chains, they have some particular uniform.
That is true. It's not just a uniform. You take a food chain, you take pizza. What pizza is it? Some pizza.
Domino's.
Domino's. Let's take Domino's. Now, when you go to Domino's and you go to another pizza place, can you make out the difference? I mean, you have not even eaten their pizza, but you just entered the premises. Can you make out the difference? Can you say that, okay, I'm now in Domino's, I'm not at Pizza Hut? Yes, you can. Why? Because it's not just the uniform of the people. It is also their layout, the color combinations used in their, in the premises.
Package.
Yeah, the kind of color combinations, the menu cards, the color combinations used in that. So there is a kind of a trade dress. There's a dress, but that is identifiable with that trade. Now somebody wants to wish you happy birthday, and they tie a little band around your eyes and they take you off to another place. And then once you walk into the place, they take off the open the band in your eyes, and then immediately say, "Oh, this is Pizza Hut," or they'll say, "This is a Taj," or there is a particular way that thing is gone about. So then they're able to identify it, and that identifiability is trade dress. However, trade dress is not protectable under one act. Trade dress has multiple components. It has a copyright in the way that McDonald's is written with that, the way it is, color combinations and so on. There's a trademark on that Mac. Then there are color combinations which are used in some things, so on and so forth. There is a copyright in the menu. And there is maybe also a design protection in the in the in the table and chairs that they're using. It may be of a particular kind of aesthetic value that is there, some kind of a ribbing or something on the chair or on the table, and there would be a design protection. And so there's a combination of intellectual property rights that could make a particular trade dress. Therefore, knowing intellectual property becomes extremely important. First, let's touch upon confidential information and trade secrets. So actually, long before the, England looked at codification of, or granting of patent or kind of granting a monopoly, let's not say patent, granting a monopoly in the way of making, some glass beaker and things like that. A long time ago, the way we actually used our intellectual property was by way of trade secrets. One of the reasons why countries became extremely wealthy, like India. India was in the ancient times, in the ancient trading times, long before the written history of, since 2000, long before that, it has been a very wealthy nation with a lot of wealth, a lot of intellectual property, and it's only when you go out of the country and you go to other countries that you realize how much they value the Indian silk or the steel from India, which even we don't value. And it's only when I went to Syria and I was walking around Damascus, this is before all these problems happened in Syria. I was there to give an intellectual property talk to the Ministry of Industry. They showed me they gave me the entire explanation on the sword of Saladin, the very famous hero in the Syrian history. And they told me that the steel was so fine and so well crafted, or whatever is the combination that is there in that particular steel, alloy being, that it could cut through a silk cloth or a cotton cloth. If you threw the cloth up in the air and it would be sliced by this sword. And they really prized it, and it came from somewhere in Tamil Nadu. And I have heard about it from some of the older generations, but the younger generation has no clue about it. We don't have it recorded in any of our historical papers unless you change and look for the old history. Similarly, silk yarn. Similarly, gunpowder. There has been so much of controversy about the crackers not being part of the the Diwali celebration. But from ancient times, we have had, I'm talking about gunpowder. I'm not actually using the word gunpowder, but the ability of a combination of chemicals to crackle and give light has been a part of our traditions from way back. It is ancient, and to be able to come up with that would be very difficult of the timings. But if you read about it, it is there in our culture, it is there in our history. It's just a matter of gathering that information, putting a timeline, which is so valued by the Western culture, that you have to put a timeline on everything. This was our intellectual property, but we normally kept it as a trade secret. People would have to come to India and then apprentice with the person or the master who is there and learn from them. One of the intellectual, trade secrets which carries on to date and which has been granted a geographical indication is the Arunmula Kannadi. The Arunmula Kannadi, of course, you have to give all the information because it's required under the Geographical Indication, Protection and Registration of Goods Act of 1999, that you have to give all the information. However, in the statement of case, they have kept that particular combination of herbs which are used to polish, which are used in the making of the Aranmula Kannadi. They've kept it secret. and it continues to be secret to date. Of course, you can go work with a master there and then learn from him, but then it is a case of being a trade secret. Now, in modern times, they also have very, very important value. Technical and scientific information, any information is a trade secret, can be a trade secret, can be a confidential information. I'll tell you the distinction between the two in a moment. Financial information, how do you price your product is very important. One of the very famous examples of recent time about pricing of product has been the case of a gourd. We call it Loki in Hindi. I don't remember what it is called in English. Bottle gourd. One of the latest of this trade secrets in bottle gourd is that bottle gourd nobody ate. You got it for really small quantity of money and you could purchase them. But suddenly they were available for 30 rupees a kilo and the prices really escalated. And people could not understand why the prices were escalating in certain cities and not in other cities. The secret of this, unfortunately, the person who was divulging this information from that company did not realize that this is his trade secret. He had not been told about it. And he divulged it in a group of people where I was also present. And he says that the reason why this is such differential pricing is there from city to city is what they do is they go to, they have found out that some places there is a great demand of bottle gold and they're not able to actually reach supplies immediately there. In other places, they just kind of throw it away after a few days. And in order to be able to look into the matter, they studied the situation in that city and they realized that every time Baba Ramdev went there to give talk on the yoga and the yoga shiver, and he had all that, a lot of people were so enthused by the idea of having, the bottle gold juice as the first thing in the morning, that there was a great demand for bottle gold. And so what did this particular company do? They sent their representative to meet with the personal secretary or the person who arranges for the itinerary for the entire year of Baba Ramdev. Found out that itinerary, and before Baba Ramdev could reach there, they made sure that there was enough bottle golds available in the markets, totally flooded, and at a premium price. And when people started going to buy them, they got it. I mean, that's what they wanted. Health is wealth. So this financial information is extremely important. Pricing information is extremely important. And of course, some are confidential information, which is important. The other part of it is that it gives you great advantage over your competitors. And therefore, it is a trade secret. So if I just look at this, all of that light blue is confidential information. It could be your lab results. It could be your discussions under non-disclosure agreements. It could be something that you snipped from a newspaper which was published about 50 years ago, but it has great relevance now. And you keep it confidential and mark it confidential. And it's in your file because it is very relevant given the new technology that is now available. So that is confidential information. So what is trade secret? Trade secret is something which gives you a competitive advantage. So confidential information, which gives you competitive advantage over your competitors, which means the onus is now on you to make sure that you keep it very safe. You make sure that that information is known to people only on a need to know basis. So the information must be secret. These are the three essential legal requirements for trade secret. There is no trade secret law in India as of now. They have been considering it for some time. So the requirement to be able to fight this case in the court, if need be, then you have to be able to establish that the information is a secret, and that it has a commercial value. And it has a commercial value also because it's a secret, because if everybody had it, it would be available to everyone at 1 rupee. So because it is confidential, there is a commercial value to it, and that the owner has taken reasonable steps to keep it secret. Given this situation, we have had a case where we managed to get an interim stay order where the plant of one company, which is a hybrid plant, hybrid cotton plant, was found growing in an area where they had not authorized it to grow at all. It was growing in some contract farmer's place. So when they found that, they took some of those leaves and sent it for DNA test, that DNA fingerprinting. And meanwhile, they made inquiries as to how do they have it, and turns out it's the contract farmer, and who's contracted his farm. They find that out, and so on and so forth. And when was it first done? 3 months ago. Did he have the same plant before? No. This is the first time he has it. Now, if you all understand what is a hybrid, so there are parental lines, they are crossed, and you have a first F1 generation. This is Mendelian genetics mostly. So when the DNA fingerprinting came and the comparison was done of the F1 line which was there with the company and the other one which was found in the farm, it was found to be almost 98 point some % similar. Identical. The court used the word identical. And based on that, and based on the background information, including breach of contract, because it was found out that 3 people left the company a few months ago, and one of them had access on a need-to-know basis to the parental lines, that is the parental seeds. And then he and the other 2 are the ones who started another company, and they have now used that to grow identical plants. Okay, there is a bit of a variation given the soil differences and so on. This is extremely important, and you must keep it in mind that, of course, there was a stay given on this, but the stay was both on trade secret aspect of it, but more importantly on the contract, breach of contract. So intellectual property is also largely dependent on how you work out your contracts. Your contracts, show it to a lawyer. It's a commercial contract. It has nothing to do with IP. Even then, show it to the lawyers. Very important, because somewhere there must be something saying notwithstanding anything mentioned above, and then immediately they take all your IPR. So it can be a dangerous situation. Okay, so we are looking at a brief history. Let me give you before this. Traditionally, we had Copyright Act. I mean, copyright was, everybody created stuff and paintings and music. And this is like I'm talking about from 16th century, 17th, 18th, 19th. They did all kinds of interesting stuff. Basically, at the time of the Renaissance, the French, I would say the European Renaissance. And all that was soft IP. The industrial intellectual property was patent, industrial. They were known as a hard IP. The soft IP was looked down upon, but they made, of course, a lot of value. They gave a lot of value to the artists, painters, poets, musicians. But the industrial property was patents on a product or some kind of a concept, inventive concept, a kind of a process or manufacturing. Trademarks on that particular product, designs on that particular product, because these are all products. And these were the main ones. So we had patents, trademarks, designs. These were the industrial property. Copyright was the related, copyright and related rights. Then we have had of course, the 1883 Paris Convention, which continued to look at it, but more importantly, the codification of what is an intellectual property right was due to various discussions at the WTO, the World Trade Organization, which came up with a treaty, that is the TRIPS agreement, which is trade-related aspects of intellectual property rights agreement, and all in the TRIPS agreement, they very clearly identified what are the intellectual properties, which is written here, and how should the nations who are signing it should look at them. So they did not lay down very hard and fast rule, but they said that generally it should comply with this. For instance, in case of plant variety protection, India was very insistent that we have to have, farmers' rights, and farmers' rights must be protected because that is not there in the UPOP Convention, that is under the United Nations WIPO, which they have the UPOP. But India wanted it like this, so they did make an arrangement in Article 27 of the TRIPS agreement that you can have a sui generis system for protection of plant variety. That means as long as you follow that it should be novel and it should be distinct and uniform and stable, or if there are existing varieties, then you don't look at novelty, but you just look at distinctiveness, uniformity, and stability, then you can go ahead and have a farmer's right. So for purposes of plant variety protection, India opted for the sui generis system. But if you look at patents, we have been signatories in, I think, 1999. We signed the Paris Convention, which, puts in some kind of a standards. We also signed the Patent Cooperation Treaty on 7 December of the same year. They were signed together. You can't become a member of the PCT if you're not a member of the Paris Convention. So we signed that. And so there is a kind of a basic way of going about it. But since India was a developing country, they gave us 10 years to comply with the requirements because it has to be drafted and put together. For instance, we never had a geographical indication protection. We didn't have a plant variety protection. They had to be created. Patents we have had since 1856 under the, not even under the Queen, it was under the East India Company. Then in 1911, it got formalized as Patents and Designs Act. And more importantly, later we have the Patents Act of 1970. I think I have a slide, I'll show you. But trademarks we had, and then we codified it again. Copyright was one of the first to be codified post-independence. And Design Act was taken from the 1911 Design Act, Patents and Design Act. And then, of course, we have the new Design Act of 2000 and so on. But we did not have geographical indication and plant variety protection, and they had to be drafted, put in a particular manner, notified, brought to the thing of the Parliament, Lok Sabha, Rajya Sabha, and passed as an act. Semiconductor and layout design, personally, I have not filed a single application thereunder. Basically, it is for the protection of the layout design. It should be original, inherently distinctive, capable of being distinguishable from any other registered layout design. Basically, integrated chips. The full name should be semiconductor and integrated layout design. So these are IPR and the applicable subject matter. So you can see this is very clear: trademarks, marks and logos, copyright, art, music, literature, design. It's a registration of objects which are visible to the eye. And Amrita has done a large number of, quite a number, I wouldn't say a large number, but quite a number of design protection. And some of them have even had patent protection on them. Plant variety, semiconductor, geographical indication. In case of patents, novelty is important. There are certain exceptions. Trademark you can file anytime. There is no pressure on that. Copyright, it exists as soon as you publish it on some media. Designs, First to file, very important. Plant variety, there is an exemption under Section 18 of the Plant Variety Protection, saying that it could have been in another country for 2 years, and then you file the application here. Semiconductor layout is also talking about 2 years or so, I understand, if I remember the act or the reading of the act. And in case of geographical indication, this is the only intellectual property which is not individually owned. An individual cannot have a geographical indication. It's usually an association of people. An Aranmula Kannadi cannot be owned by one person. It has to be an association of people who have a right over this. Almost all the intellectual property go through this process of filing, exam on the criteria, compliance, IP specific processes, grant of that particular IPR. If it is not, if that IP process is rejected, then you can go in appeal. And if the appeal is rejected, then you can see how you can go about it. Incidentally, we have about 300 odd geographical indications in India. And I think the first one was the Darjeeling tea. And you can get it on fruits, on handicrafts, basically any goods. And this is how we have moved. Patent, trademark, copyright, design, and then we have moved to this, and now we have more biodiversity rights and so on. This is how Patent India evolved. And need of the times is what we looked at. And in the process, we've had new amendments to the Act, new laws. Biological Diversity Act is not an intellectual property right, but it has certain sections which apply to intellectual property right. So you need to look into it. And I think I have come to the end of this slide. And just quickly, if we want to look at patents, we would have to very clearly demarcate it between two different fields solidly. I mean, and I say it from the point of view of being a practicing patent attorney as well as an advocate. If you have technologies which are quickly evolving and moving on, have nothing to do with life sciences, there is a completely different approach to it, and it's very important. So with regard to patents, you would have to look at what are the requirements before you file the patent application, the requirements at the time of filing patent application, and the requirements which are there post the filing of the patent application and the grant of patent application. So some of the things beforehand that you have to do in any case is prior art search. You can do it yourself. You don't have to go to a attorney to do it for you. But if you go to an attorney, you get a clearer idea because they have various kind of machines subscribed to engines, all kinds of engines to do searches in 105, 10, 15 countries and come back to you with inputs. But it is also capable of being done on your own initially so that you don't reinvent the wheel. And what you have is something new, which can be protectable under the Patents Act. In case of life sciences aspect, it is very, very important to see if you're accessing any bioresource from India for purposes of working on your particular invention. And if you're doing that, it is very important to get in touch with any advocate who is or any person who is skilled in the law of biodiversity laws of India in order to comply with that requirements under the Biodiversity Act for purposes of research. I see a hand up. I'll just come to you for purposes of research, for purposes of commercialization, and also transfer of results of research. Yes, there is a query. There is a hand up.
Yeah, participant can unmute and ask.
Ma'am,
Yeah.
I have a doubt, ma'am.
Right.
If I am an Indian student and I am doing my research abroad, suppose it is in US, so I have something to patent. So where should I apply, in India or in US or for international like patent?
See, you can apply it anywhere, but there is a requirement that if you are developing that particular patent, the invention while in India, and you want to file it in the US first, then you must get what is known as a foreign filing license from the Indian Patent Office. It is a very small procedure where you give a brief abstract of your invention and file this is under section 39. You file this for a foreign filing license and you will get it within a week. If you're taking an attorney like a patent agent to do it for you, you must also give that patent agent a power of attorney along with your abstract, and they will file the forms and they will within a week we normally get the foreign filing license. As soon as you get the foreign filing license, you can file it in any country of choice. However, if you're first filing in India, you have a complete specification. You're first filing in India, then in case you want to file the PCT application, you would have to wait 6 weeks before you file the PCT application. Because there's a requirement under section 39 that after filing in India, you have to wait for 6 weeks before filing abroad, just so that the patent office can check and see if there is anything related to defense related invention or thereabouts, which would then undergo to secrecy or atomic energy related invention, which will then undergo under the secrecy laws under section 35 of the Patents Act. The third point is, suppose you don't want to get a foreign filing license, it's unnecessary thing. You're anyway going to file in India. Then you file in India a domestic patent application and wait for 6 weeks and file in US or any country of your choice, or PCT application or Paris Convention application. Does that answer your question?
Yes, sir. Thank you.
Yeah, thank you. Any other question? Yeah, yeah.
Ma'am, one more question, ma'am. Ma'am,
Yeah.
actually, the sandalwood, like in sandalwood plantation is not allowed, right? That is for common people, it is not allowed. It is only government is owning to cultivate the sandalwood. Does it come under this plant variety protection or like biodiversity protection or geographical indication protection or something like that? Or
See, yeah. So any person can file for intellectual property law under the Plant Variety Act. Any person meaning which includes government as well. So if you have, for instance, UPASI, the Union of Planters of South India or something, and they have come up with a hybrid of some, I don't know, hybrid of a sandalwood if it comes, that being a saprophyte. But if they have come up with a new variety or something, and there is another law in the country which says that this is high value product and only government will do it, then in that case, UPASI being, whether it is whichever is a body which is a government body can apply. For instance, the Spice Board of India can apply for certain restricted ones. If they come up with some new variety, then they can apply. So when you say any person can apply under the General Clauses Act, unless it is clearly said no, the any person also includes government.
Okay, ma'am. But sandalwood is not like a rare variety or something. But according to the law, it is punishable if we plant it at our home. So, does it come under this IPR or not? That is
No. IPR is a voluntary protection that you would do for any thing. So if it is a plant, and if you've done some kind of a new research on it, and it shows novelty, distinctiveness, stability. I mean, I'll have to probably have another session on plant variety to go into details of that. Then it's fine, but it's a voluntary thing. But that voluntary law of IPR is subject to all other laws of this nation. So if there is a law which bans you from having a sandalwood in your home property, you can't. It is a criminal offense.
Okay.
See, the laws of a nation has to be harmonized. And if they're not harmonized, we have to take the matter to court and say it needs to be harmonized. We have recently done that for the Biodiversity Act, saying that the way the Biodiversity Act looks at foreign entities is not compliant with the companies law of India or the income tax laws of India. And it needs to be harmonized because it causes confusion and there's a lack of, in the ease of doing business. So all the laws of India have to be harmonized. They have, if they're not harmonized for whatever reasons, then it is our duty as the general public to bring it to the notice of the respective ministries and see if something can be done. If they still refuse to do it, you see the finance ministry is doing a lot of rolling back and everything because it's trying to harmonize everything. It is not a weakness, it's a strength to be able to take inputs from the public and make changes. But if they refuse to do, like in case of Ministry of Environment, matters have gone to court.
Okay, ma'am. Thank you.
Okay. So just to close, I think my time is up almost. Just to close, please keep in mind that pre-filing of your patent application is extremely important. It is experimental data is something that if you have, great. If you don't have that experimental data, make sure that you have that particular clause in your or a sentence or a statement or a paragraph in your patent specification that it is undergoing the clinical trials or whatever for the purposes of developing experimental data is underway, because there's a big clash there. The experimental data takes time to do it, and yet you have to be the first to file. But in a situation where you are very sure that you can get it within 5 to 10 months, then the Indian law provides you the option of filing a provisional application which gives you the right to claim that particular date of filing. But at the same time, you do not have to give all the experimental data. You have a period of 12 months from the date of filing the provisional application to provide all that information, file a complete specification, or thereafter filing it in across the world. So if you are sure of that kind of a timeline in which you can get information, great. Please remember, any kind of synergistic work which is being done will require some kind of experimental data in any case in your patent specification. Yes, there was a question.
Ma'am, does this type of that is patents we have applied and that comes under patent pending like that?
Yes.
Yes. Okay.
So patent pending is something which is a two-way sword. There is no requirement presently under the law to write patent pending, but there has been an advisory that you can write patent pending. Now, why did I call it a two-way sword? Because once you mention patent pending, then your competitors are waiting to see the moment it is published, then they can file an opposition. If they don't know about it, they won't file an opposition. They will, unless they're keeping a watch for all the pharma molecules or the pharma compositions which are on which patent applications are pending. There is anyway a watch being kept by certain groups of NGOs, and the moment it gets published, they file oppositions. Or the moment it gets granted, also they file an opposition. So you may want to write or not write, I'll leave it to you. But you can definitely mention it in your documentation whenever you are having any discussions with another entity for purposes of licensing. Please note that licensing is not necessarily happening at the end when the patent has been granted. It can happen the day after you file the patent application. And I would prefer it to happen after you file the application, because there's a very clear demarcation and there is a scope which is there. And if you have the complete specification, you also have the claims which is there, which defines the scope of your invention. So it is not mere conjecture, it is written down there. and you can start discussions way in advance. And of course, a lot of people will tell you it is not a good idea, but the way your contract is written would be very important. There have been instances where universities have immediately gotten into licensing arrangements with companies. Patent has not yet been granted. So there is a milestone approach to that agreement that in first instance, the patent application, there is a down payment given to the inventors or the team of inventors or the university, however it is, put together, or the department. Then then there is a hand-holding period where technical know-how and everything is shared by the inventors, so that there is payments for that also. And once a patent is granted, then there is a complete relook on how the royalties will come through. And when they get approvals, if there are regulatory approvals involved there, with regulatory approvals also, there'll be some payments. So those agreements would be your patent team, your patent office in your organization has the onus to really look at these agreements and see that you get the best out of these kind of arrangements. Does it answer your question?
Yes, ma'am.
Ma'am, one question, ma'am.
Yes.
Ma'am, many technological products have been coming up, but China is able to reproduce a duplicate product of it. How we can avoid that, and how is China is able to duplicate the products?
We can also duplicate the products.
Sweden will not allow, ma'am.
See, duplication is not a problem. The problem is, what is the kind of enforcement that is there in that particular nation? If the enforcement is weak, and there was a time in 2013 or thereabouts, where the patent office itself would give information on the patent applications to the Chinese, the ones which are filed. I will probably be sued for this statement, but this was out in certain meetings and conferences and discussions. So it is very hearsay. I have nothing in writing which says it is. So please don't bring it to notice of various authorities and say, okay, she said it and therefore it is. But the fact of the matter is, there was a concerted effort on part of the government of China to make China the hub of world marketing, the world hub of not marketing, manufacturing. So China actually, before this badwill, actually loss of goodwill due to COVID, China actually was the manufacturing center of the world. The copying part of it is very simple. There are no enforcements. Nobody is putting agreements properly in place. If you have an agreement with a person in-house in China to manufacture, and that person has have to be made further agreement with a small parts manufacturer, all of it just goes, and it's very easy to do it. In Japan used to do it a long time ago, till they shifted. It is in the life cycle of a nation to become nation. It's a nation building exercise. So post World War II, Japan had a similar reputation of being a copycat nation for most of the products. However, you will see that the way their management systems are, and the way their support systems are, and how the big management companies work, big manufacturing companies help the small manufacturing companies. They have various names for these, which is very, very unique to Japan. They were able to come out of that situation very quickly. Today we say made in China, ignore. There was a time, I think it was in the 60s, where it was made in Japan, ignore. The only thing that came from Japan, which everybody valued a lot, were the Japanese toys. The doll, Japani Gudiya. And anybody who went to Japan got a doll, which is a Japanese doll. But you see Japan now, they are at the forefront of practically every latest technology. Same thing happened with South Korea. You look at LG, life is good or something like that. I mean, that's what it was. Then they were also copycat, but they rebranded themselves, became, a country which has very, very, very reliable automobiles. If I really need to look at an automobile, I would probably look at, something from Korea or Japan. I won't look at anything from the US. And I think so. China is going through that life cycle. Right now, they have very good products. There is, I forget that fridge, it is refrigerators, and that is high brand refrigerator, which is very, it's not a copycat thing. What should you do as an inventor to protect your inventions? Actually, not much. You can just make sure that you're alert to what is happening, and wherever they're sending it, like they were for one of our Italian clients, they were manufacturing those bolts for the copper ones, for the pipes which you put in the buildings for water, this, that, and all. So they had these various joints which are very high value, elbows they call it, and that was being manufactured in China. So we caught them at the port of entry in Chennai and sued them, and sued the person who had given, who was receiving it. So those are ways to go about catching them, because if you go and file it in China, it takes its own time. I don't know how quick they are now, given the present situation. In between, they had become very, very fast in, taking care of enforcement, ensuring that people did not have counterfeits and duplicates and so on. But how is the situation on date? I don't know. But one way to do is catch them at the ports of entry of the countries of interest. The Italian company had their country of interest was India. So when they gave us this thing, then we had field investigators investigate this. They found out what is happening. We gave this information, and the customs was informed under the, the Rule 11 of the Customs Act, where intellectual property can be notified with the customs office, and they can seize it at the port of entry and then take the matter before the jurisdiction. This was the Madras High Court. Does that answer your question?
Yes, ma'am. Thank you, ma'am.
Okay. Any other questions? Because I think I've run over my time.
Ma'am,
No, ma'am, we can have, if there are any questions, we can have them now.
Okay. I'll be happy to take questions.
Yeah, thank you, ma'am.
Thank you, sir. Thank you, ma'am. Ma'am, actually, ma'am, I have a doubt, ma'am. If somebody is they are having some patent, and which is already like commercialized, and he or she is getting some revenue from that, and accidentally she or he come to death, and what would be the procedure like that? If that is that patent is valid after his death? If so, who can avail that revenue?
Right. It is like this. Patents is a movable property, is deemed to be a movable property, right? And this is by way of some judgment. It's also there in one of the sections, I think section 68 of the Patent Act. I have to check the exact section. Don't go by what I'm saying right now. Let me check that out. Now, how does the patent right devolve? It devolves to a person from one owner to another person by way of assignment. That is a sale, which the dean was talking about. You sell it. Yeah. Sale is called assignment. You have the entire assignment of rights. Second is by way of operation of law. Operation of law is a euphemism for death. So suppose, like you rightly pointed out, somebody who owns the patent application, who was getting the revenue from that, or whatever, if he dies, then his legal heir, which is a different set of actions, because you'd have to go to the local, I think the office of the registration of births and deaths, get the death certificate, then produce the death certificate before, I don't know exactly who in that particular district. and get yourself the survivor of that particular person. And then once you have that, then you can file this document along with your request for transferring it in your name, and it will be taken on record at the patent office. So if you're a licensee, it will be taken on record there, because every licensee also gets registered at the patent office. Once you do that, you can also go ahead and, of course, your partner from whom you're getting the dues will always know about it. Just a minute. Because you would have immediately informed them, or he would know about it. So the dues would be coming anyway into the bank account. I mean, the royalty, not the dues really, the royalty payments would be coming into the account. And as the heir in the bank records, you have the right to it. But in the patent office, you can record it like this. Legal heir certificate.
Sunita, can I add to this?
Yeah.
This is Salma. I just want to talk about how this works in Amrita. So all of our patents are filed under the name of the university. So the owner of the patents is Amrita Vishwa Vidyapeetham. Before we file a patent, all the inventors sign an assignment agreement, assigning the rights to Amrita Vishwa Vidyapeetham. And then sometimes there's a commercial agreement between the university and the inventors. That is something that's still evolving in our university. So in terms of Amrita, it would, if the person was, and we've had cases of inventors passing, so it would depend on how that commercial part of it, as Dr. Shashangan was saying, the payments or the royalties or whatever is worked out between the faculty or the inventor and the university. So I just wanted to add that point.
That is very important, because the agreement between the university and the inventors is a very important agreement. But if you ask what happens in the patent office, then I've given you the patent office perspective.
Okay, ma'am. Thank you.
It's very complicated questions. It's very nice to know that, you know, it's beyond novelty and inventive step. If you have questions on Patents Act or Biodiversity Act or anything else, please. Plant variety, yeah.
I have a question from like copyright issues. Like if we are all are reading newspapers, and if a YouTuber or somebody is reading that newspaper content in his or her YouTube channel, does it be a copyright issue?
There was a recent judgment on that, saying that we are not going to do it in India, because they did that in Australia. And if they had this news which is produced, reproduced, so reproduced in any of the social sites like Twitter or Facebook or something, then they would have to pay, or Google, they would have to pay for it. And I think that's ongoing in Australia, and I think some other countries. Australia, I know for certain. Other countries, I'm not so sure. And they try to apply the same thing in India. And in India, I think a very, very recent judgment, I think 10 days ago or thereabouts, where they said that no, news is free. What is important here is how do you represent it? Now, for instance, let me give you one example where we went to court with regard to information, news information, because you're dealing with a set of facts which cannot be changed. It happened, so it happened. Now, how do you present it? So if you have a GUI, I mean, the graphic user interface, and there you have the news appearing in a, in a certain manner. For instance, if you go to Bing, the news appears in a manner which, you have the information on the top right, and it keeps rolling. And then you have all kinds of, it's a very cluttered kind of a thing, which makes you waste a lot of hours reading each one of those clicks. If that entire is reproduced as it is, with even the news coming like that, because news is ephemeral aspect, but the GUI, the way it is represented, there is a copyright in that also. So you would have to be looking at what part it is. Is it just the information which is presented as it is, which is perfectly fine? But if it is presented in a particular manner, like if you see the financial news, which is there in moneycontrol.com, rediff.com, and so many other, information sites, are they looking the same way? Are they using the same emblems? If they're doing the same, then you would like to look at the copyright issue. Otherwise, just reproducing news is not a offense. Copyright, under copyright.
Okay, ma'am. Thank you, ma'am.
Mm-hmm.
I think it's time. We'll thank you so much, ma'am. Very fascinating examples you gave. Give very good breadth of information we got on the intellectual property. I think we have eaten into more of your time also. Thank you very much, ma'am, for your excellent insights. Now I request Salma Jeta, ma'am, our patent coordinator, to take over the session and give us insights on the process in Amrita. We have almost 200 plus attendees, and all of them are doing some kind of research, but there are kind of hidden gems in all this research which we would like to kind of take it to the next level in terms of patents or designs or copyrights and so on. Over to you, Salma, ma'am.
Okay, thank you so much. Om Namah Shivaya. Thank you for inviting me.
Thanks, Anita. Thanks.
No, Shivaya, Salma, ma'am. We can hear you, ma'am.
Okay, great. I want to share my desktop.
Yeah, you can do that.
Does that browse my computer? Is that sharing my desktop? Yeah.
No, not yet. Nothing. It's not come. You have that the arrow, right?
Yeah. Okay, I see. I'm just gonna. You can see my screen, right? Okay.
It's coming. It's coming.
Okay.
It's visible. It's visible now. Yeah.
Okay. So, does this need to be bigger? Can you see
this? No, it has to be in slideshow. Put it in the slide.
1 second. Is that good?
Yeah. That's good. That's good.
Okay, great. Okay, so I'm Selma. I'm the patent coordinator for Amrita Vishwa Vidyapeetham. I think I've been doing this role since 2013, and I oversee the patents, copyrights, and trademark filings for all the campuses except AIMS. So the medical campus is overseen by Dr. Shanti Nair, but for all the other campuses, you can contact me. And I'm going to give an overview of the process. And if there's questions, we can just ask as we go along. So Sunita, we didn't have a big background on her. Sunita is the founder of a company called SKS Law in Delhi. And she's one of the lawyers that we use for our patent filings. She's not the only lawyer, but she's one of them. And she's also an attorney, which is a huge advantage. So as you can see, she has that breadth of knowledge in the patent IP world. It's very, very useful. So I'll just give a little overview. Why do we file patents? One is for IP translation for societal benefit. So in Amrita, there's a huge emphasis put on what are we doing and how does it help society? And that is one of the reasons we file patents. Sometimes the patents that we file might be very similar to existing patents, but it's a way to do something in a much more cost-effective way. And you can also get a patent on that type of thing. So process patents are also available, and we do file patents many times for that reason. The other thing is to promote innovation in frugal environments. So same type of thing, cost-effective applications in using locally sourced technologies and materials. We also want to protect our intellectual property for commercialization and deployment. So approximately 40% of our technologies are deployed in the field. And I'll go through that. And then we also get recognition for Amrita and our inventors. The inventors are named in the patents and for our university rankings. So these are our key technology areas. Biotech and life sciences, health sciences, molecular nano. This one is mostly the patents from Ames campus. And as you can see, these two, medical life sciences is kind of half. These are our granted patents. So right now we have almost 70 granted patents, and half of them are in the medical life sciences area. Then the other half is mechanical and related applications, wireless networks applications, we have 14. Computer science and engineering, there's 9. And then these smaller ones is learning technologies and energy and solar. So these are the key areas that we file our patents. And this is sort of gives you an idea of where we've gotten our patents granted. Then these are some of the examples of our deployed technologies. So from Ames campus, the core shell particle formulation for drug delivery, there were 2 US patents. This technology actually got commercialized to a company in the US, and the patent was assigned to them. And then there's also a titanium-based cardiovascular stent, which is also has an Indian patent. WNA wireless networks, there's a coastal offshore mobile communication system, remote health monitoring, and then biotech and life sciences, we have a non-enzymatic glucose sensor patent. There's 2 design registrations on the reusable sanitary pad that has a huge reach right now in India. And computer science, there's an IoT gateway and the healthcare information system, which, as many of you might know, is used at Ames and also commercially being distributed. So these are some examples. I'm going to show the actual patents in a minute. So this here is a graph showing the growth in our patents. So in 2011, the blue is the foreign patents, and mostly these blue ones are US patents. And then the orange is the Indian patents. So as you can see, until 2016, we had 1 or 2 patents granted each year. And then there was a big shift, 2017, we started getting many more per year. And this year, this has been really interesting for me because most of our patents that have been granted are foreign and mostly US. But in 2021, for the first time, we have more Indian patents that have been granted than the US ones. I think this year we have 9 Indian and 7 US, and the year is not over yet. So that's been really interesting for me to see. The Indian Patent Office has gotten much better with granting and processing our applications. So they used to be really slow. In the past, the US patents would take maybe 3 to 5 years, depending on the technology. And the Indian patents would take somewhere between 5 and 10 years. And now it's the Indian Patent Office, the IPO, is getting much faster. So I want to actually show some of these patents. That's what I'm going to do now. Okay, let's see. Okay, here's one example. Can you see this patent on the screen? I hope you can see this.
Opened, Selma ma'am. Yeah.
You can see it?
Yeah, mobile
Okay.
infrastructure for coastal.
Yeah, so this is the mobile offshore. It's basically the offshore communication system for fishermen. And the Indian patent was granted in 2018. This is the patent number 100452227, US patent, Rao et al. Here's the name of the patent. And then the applicant in our patents is always going to be Amrita, Vishwa, Vidyapeetham. And we're headquartered in Tamil Nadu, so usually that's the address we use. And then the inventors are also named. So Sethuji, Manisha, Dr. Venkat. The assignee is the university. And then these are sort of what the first page of the patents all look like this. Prior publications, some other references when we first filed. So this was filed in 2016 and granted in 2018. The Indian patent was also filed in 2016, and that one is pending right now. So the patent has an abstract. These patents are written by our lawyers. So we use about 4 to 5 different firms, depending on their technology or area of expertise. Some of our patent agents specialize in computer science, some in life science, wireless. So they have different areas of specialization. The abstract is first. this patent has 12 claims and 2 drawing sheets, and you can see the little boats and how the communication system works. Here's a blowout of that drawing. And then a bit more on the communication and how it works. And then here it's the background of the invention. The patents all follow the same format. The background, the summary, a description of the drawings and the invention. And then going down, the most important part of the patent is at the end. And these are the claims. So the invention claimed is 1, a marine communication system. So the first claim is like an independent claim, and it describes overall the system. And then there's usually a series of dependent claims that go into further details on that claim. So this patent, these are the dependent claims, 2, 3, 4, 5, going down to 12. So that shows you kind of an overview of what a US patent looks like. This one is an Indian patent. I hope you can see this. It's a blue certificate. The Indian Patent Office doesn't give the full patent when it grants a patent. They give a certificate like this. So this was a device for sensing fluid pressure. And we filed this patent in 2012, and it got granted in 2021. So you can see in the past, they did take a long time. Hopefully it's getting faster. The patent number is 379561. Our application number is here, the date of filing, and then the patentee. And the inventor is typically named on here. I don't see it on this one, but usually the inventors are named. It's a device for sensing fluid pressure and granted under the Patents Act of 1970, like Sunita was saying. Okay, this is also an Indian design patent. So there's different types of patents. Most of the patents we file are utility or process patents. This one is a design registration. This is for a medical keypad interface. A design patent is only for the look and feel, not the working. So same thing, this was granted in 2013, date of issue. We filed this in 2012, and the design patents are quite fast because it's just on the physical, how it looks and feels. So you can see this is a keypad interface for a medical device, the different views. And that's pretty much what a design patent will look like, showing the different views of the device. Okay, and then this is from the Coimbatore campus. So this is a lab-on-chip device, a biotech device, and Satish Ji is on here. He's going to talk next. But this was done with, I think, the sensors lab in the Etmarai campus, Coimbatore campus, along with the Amrita School of Biotechnology here in Amritapuri. So the patent number, this was recently granted, 2021, and this one was filed in 2019. Oh no, 2018. So the biotech patents in the US Patent Office take a little bit longer to process than the wireless networks. So the wireless networks, the technology moves quite fast, and so the Patent Office reviews and grants those patents quite quickly. And same type of thing, same format, the abstract, what the chip looks like, and then other references, more details on the design, the sensors, how it works, same type of formatting as you can see. Okay, so those are some examples of our patents. Okay, so how do you know if your idea is patentable? These rules are applicable throughout the world. So no matter where you are, the criteria for filing a patent is the same. So first, it has to be beneficial to society. It can't just be an algorithm that solves a mathematical problem. It kind of has to do something. So it can be an algorithm that does something, but a straight algorithm that, solves a math problem is usually not patentable. The other thing is mostly software is not patentable in most countries, unless the software is part of a hardware system. So we have a lot of examples of those. And that's typically how we file our software patents, is part of a hardware system that does something. So the first question is it beneficial to society? Does it solve a problem or process? And does it have an industrial application in the broadest sense? The other thing is it has to be new, novel, and not obvious. So this is why it's really important to file a patent before you publish. So the US and India both have these grace periods. Both countries give you 1 year from the date of publication that you can still file a patent. But it's really, really better to file the patent before you publish. It really protects the IP much more. So we do a prior art. Sunitha mentioned that. It's good if you, before you submit an application to the patent office, you do an evaluation yourself to see, oh, is my idea, is it really novel? We almost always have the lawyers do a prior art search as well, and I'll show you an example of that. So the claims, what are the claims? What do you feel is novel about your idea? And then non-obvious is a key but tricky criteria. So not obvious means someone in the same field cannot solve it readily. And usually we have to prove that. So we go back and forth with the patent office trying to prove that it's not obvious. So as I mentioned earlier, not purely theoretical, should have a practical benefit. And then the reduction to practice. So technically the patent should work, but in patents, we don't have to necessarily prove that it works. Some of the technologies, usually the biologics, we have to get proof. But then for the mechanical ones, like drones that harvest fruit or other technologies like that, we don't always have to show that it works. So these are some big differences between patents and publications. So the question often comes, should I patent or publish? So these are some of the differences, and you can do both. You don't have to do one or the other. So if you want to do both, you should really file a patent before you publish. So a patent creates an IP right for 20 years, and the 20 years starts from the date of filing. So that's what Sunitha was mentioning, that it's good to start some of the commercial negotiations as soon as you file. In India, you can enter into a commercial agreement as soon as the patent is published. In the US, it has to be granted. In India, because it takes so long to grant, the government gives you the right to enter into a commercial agreement as soon as it's published, but you can't file for infringement until it's granted. Okay? And with patents, they're automatically published 18 months after filing. So yeah, that's an automatic thing in all the countries. I talked about inventor assignee. Data results are typically not included in patents, and the reduction to practice we don't often have to show, and the patent office does the review. So both the publication and the review by the patent office can be expedited with a fee. Okay, publications, I think you're all familiar with these. It has to be reproducible research. It gets reviewed by your peers. You always have to show data. The authors, there's certain criteria for authors. I think I'm not exactly sure of the authors and the author criterion publications. I believe that anyone who works on the idea can be named on a publication. With a patent, it's a little different. So inventors are people who thought of the idea or they figured out how to make it work. Those are inventors. So if you have a lab and you have students working on the research, if you thought of the idea and you designed the experiment and the student just executed the experiment, the student's not an inventor. You can put them on a publication, but they're not an inventor. So it's a key difference that it's important to keep in mind. A lot of times people want to put other people in the lab on patents just because they want to, but it's not. We need to be careful of who we name on patents. The other thing is that the patent is a property right, whereas the publication is not. So, and all the inventors have equal rights in the patent. So it doesn't matter what order you name the inventors, everyone has an equal right. Okay? So I'm just going to go through our filing process. Are there any questions so far? Make this a little bigger. Okay, so this is our filing process. The researcher has an idea. So the researcher can be a faculty, a staff, a student, a group of researchers. You have an idea. Then you want to know, is my idea novel? So it's good if you do some research on your own. I get a lot of patent disclosures and people think, oh yes, my idea is definitely new, definitely novel. And then we start looking at it and we find it's not new and novel. And we are careful about what we file because it costs us money. So we try to file for patents that are going to get granted. So they're not always granted, but there's also a cost involved. So we try to evaluate the ideas and make sure it's something that can be granted. So what you're going to do is once you feel like, yes, I have an idea, it's commercial, there's people that want to publish my, commercialize my idea, I want to file a patent. Then you can contact me, patents@amrita.edu, and you need to fill out an invention disclosure form. So that looks like, where is my, oh yeah, here. This is our invention disclosure form for the university. So I need the title of the invention, the names of the inventors in the order. Did you have any external funds that you used to develop the work? So I need to know that because that implies some rights for those people. And sometimes the government funding has certain requirements related to IP. So I also have to check that. So if you use any external funding, just put in here the institution, the PI. Then I need to know the date of the conception, if you've disclosed it, the first oral public disclosure, if it's unpublished, when you plan to publish it, if you've prototyped it, yes or no, or when you plan to prototype it. And then this is the assignment, the inventor signatures assigning. HOD has to also sign. And the last page has all the instructions for the invention disclosure. So that I also need. So once I get the invention disclosure, we go through a review process, and then we make a decision. There's a management review, whether we're going to proceed. So once we decide, yeah, this looks good, we're going to go ahead, we determine which firm is going to do a prior art evaluation. So the lawyer will complete a prior art, and this is what a prior art evaluation looks like. So patentability search report. This one was also on an invention that's currently pending with the Indian Patent Office on a beach erosion system. This is out of the Coimbatore campus. So here are the references. And then the lawyer always gives an overview of their understanding of the subject matter. So after I get this report, when you get the report back as the inventor, you should make sure they understood it correctly. Yeah, and they break it up into elements. So E1, the beach erosion prevention, E2, concrete slabs, E3, E4, they break it up into aspects that are patentable. And then they tell us the methodology, they use these keywords, and these are the classifications. So there's classifications for different technologies and areas, and then the sources that the lawyer used to do the search. And then they give us the results. So this goes one by one from the closest search result to the least closest. So you'll get the report, you can review all of this. And the most important part for me is actually at the end. I'm just going to skip there. Okay, so this is at the ending, the conclusion. So I get the report, this is what I look at. Here's all the prior art. So prior art are similar technologies in the same area. And when it says US blah, 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 that's a US patent. KR is a different one. WO is, it's a PCT patent that's under WIPO. So these tells you the different patents and or documents. They can also be publications. Yeah. And E1 are those elements of the idea. And then if that disclosure covers it, So you can see it's partially disclosed, and then when it's a dash, there's a lot. Sorry, I'm right by the road. There's many aspects of this invention that are not disclosed. So then the lawyer gives us a rating from 1 to 5. And this is true for all disclosures. It's not a black or white, should we file, it's a grayscale. So 1 means there's no close prior art. That's something we would definitely file. And 5 means very close prior art. We're unlikely to file something that gets a 5. But a 3, there's close prior art, but it's possible to differentiate. So usually, and this one we did file and it's pending. So this is what a prior art report looks like. So then once I get the report back, we review it in the patent office, and I also send it to the inventors. And then we make a decision whether we're going to proceed. Yeah. So that's our filing process. Okay, so we have the invention disclosure form, the assignment agreements. I talked about that at the end of Sunita's discussion. So before we file a patent, the inventor, I have to get the assignment agreements. The patents are all filed in the name of the university. The university pays for all the filing costs. And then if there's any commercialization, that part of it is worked out with the inventors and the university. The commercialization is something we're just starting to get more into. And if you have an idea that you feel has commercial interest, there's different ways that you can commercialize in the university. So it's good if you, for example, there's the TBIs, they have funding for commercialization. We also have different companies that we use. There's different licensing, consulting agreements. There's a lot of different pathways to commercialization. So that is also really getting more and more concrete within the university. And then the filing process, I'll go through that. So Sunita talked about this. In all the countries, the first to file gets the rights. So if 2 people file the same idea, the one who files it first owns the right. They have the first right to that technology. That's why Sunita was saying there's a lot of patents filed. So if you have an idea, it's not quite developed, but you feel like it's really novel, we can file something called a provisional patent. And a provisional patent is like a concept agreement. It's not a concept agreement, it's like a concept paper. So we can file that quickly and easily, and then that gives us 1 year to file the full patent. But you can't add on to that within a year. So the provisional should basically capture the main parts of your invention. Sometimes we file, several patents in one technology because the one patent doesn't cover all aspects of it. And this is done a lot. So if you have an idea, you're still developing, you're not sure, you haven't finished, but you feel like it's really novel, we can file a provisional. That gives you 1 year until November 1st, 2021 to file the full patent. The other thing is that you can also decide within that 1 year period, oh, I don't want to file, it didn't work out. That happens also. And we don't lose anything by not filing a complete patent. And the idea also stays private because it doesn't get published. So it's another way to protect the IP and the technology without going public, so it doesn't get released to public view. If we have any international patent, that also has to be filed within 12 months of the priority. So if we file a provisional patent November 1st, 2020, we have to file the complete spec in India and any foreign patents within that same time period. The other thing I want to mention here is that there's a lot of companies sending emails to Amrita faculty saying that they can get you a quick Australian patent. So India has a law. If the inventors are Indian and or the technology was developed in India, you have to file in India first. These firms that tell you you can get a quick Australian innovation patent don't tell you this. And there's quite a few people that have filed these Australian patents, gotten them granted, but actually it's illegal because if you don't have a foreign filing license, it's a criminal liability in India. So I've been trying to notify our faculty to be very careful of these scams. So if you get something like this and you think your idea is patentable, please contact the patent office. Okay? The patent's published after 18 months, and then the prosecution, that means the prosecution is the back and forth between us and the patent office on the patent. Because what happens normally is the patent office, whether it's India or the US, they automatically reject it, saying that, oh, this one's already there, yours is not novel. And we have to defend our patent and our ideas to get it granted. I've had a few cases where there's no prosecution. That means the idea is so novel that it immediately gets granted. But that doesn't always happen. And then in India, the patent offices are spread out over, I think, Mumbai, Chennai, Bangalore, Delhi, and each of the offices, each of the offices has specializations. So basically, if you file a life sciences biologics patent, it usually gets reviewed by the Mumbai office. If you file a computer science patent, it normally goes to the Chennai office. In the US, they have art units, which are split up by the technologies. And so the examiner reviewing the patent is knowledgeable in that area. Okay. So this is my contact info, salma@amrita.edu or patents@amrita.edu. And then these are some of the key websites that you can search. Patents, Google Patents has a lot of info and references to patents. They don't have the Indian ones, but they do have a lot. And then the Indian Patent Office is IP India, the USPTO, and then our website is just being overhauled. So some of our patents are there, but that website's not really complete yet. So it's just being worked on. So that's a little overview on our patents. Any questions?
Yeah, Salma ma'am, I'm sure there are a lot of questions. I have a question actually. We do get this, since you talked about this Australian thing, the scam thing. There are even people who call you and say that we'll do, the main thing is the Australian thing, but they also do some Indian filing to make it legal. And can you just throw some light on it? Because they say that, we get this crank calls, we'll do an Indian and Australian patent. So how do we respond to those kind of folks?
Yeah, I think it's best if you contact me or the patent office. Because actually, I've done some research on these firms. They're actually Indian firms. And it's amazing how many scams are in India. Like people, I don't know how there's so many scam artists. And the thing is that they sound very professional, like they know what they're doing. They're going to get you this patent, but really it's almost a complete scam. Yeah. So, and we have a patent office in the university. The patents are filed in the name of Amrita, and the patent office, we pay for the patents. And then they count towards our accreditations, and we also then protect our technologies for commercialization. So as much as possible, if you get any kind of scam calls like this, please contact the patent office.
Yeah, that's a very important thing, because I'm sure many of our research scholars, faculty members who are doing research are getting this kind of crank. So we should know how to respond also.
Yeah. It's mostly a scam thing. I guess there are a couple other things I forgot to mention. In India, once we file the patent and get it granted, we have to show that we're using it or that it's deployed somewhere. So if the patent's granted and we're not doing anything with it, the Indian Patent Office can license it to somebody else. And I actually think the Indian Patent Office does a lot of things too. The societal benefit is really protected in India. For example, like there's many pharmaceutical companies in the US, they'll keep getting a new patent on a pharmaceutical that's already out there. And what they do is they just add a molecule somewhere and get a new patent. But it doesn't change the efficacy of the pharmaceutical. In India, in order to renew that patent, you have to show there's an improvement in efficacy. So the Indian Patent Office has a deep interest in protecting the IP also for societal benefit. It kind of goes along with Amrita and our goals, but we have to actually show proof to the Patent Office after the patent is granted that we're using it or it's deployed somewhere. Okay, any other questions?
Yeah.
Hello, ma'am.
Yes.
Can you hear me?
Yes, I can hear you.
Yeah, this is Mohan Kumar from Amrita Vishwa Coimbatore campus, Chemical Engineering Department. Yeah, from the date of filing of the invention disclosure form to the Amrita Patent Office, how long will it take for the Amrita Patent Office to communicate to the authors about the decision of whether it is a black and white decision, whether it is moving forward or it has been not been taken up for further process?
Yeah, I mean, I'll usually let you know that. I mean, usually once I get an invention disclosure, I'm in communication with the key contact person on the disclosure. So sometimes what happens is I get a disclosure and the inventors, they don't want a prior art search. They want to get it filed right away because there's some commercial discussions going on. In those cases, we do file the patent right away, depending on what it is, and as long as I get management approval. And then after that, we do an evaluation. So sometimes I'm in regular contact with the inventors. So sometimes the process does take some time. So for example, if we're doing a complete filing, that's the full patent filing, that sometimes can take time. So if you've submitted for publication and you've submitted a patent disclosure to the patent office, you have to let me know that you've submitted for a publication. And if your paper gets accepted to be published, I also need to know that date. Because sometimes we file something quickly because we want to file it before publication, and then we go ahead and complete the full complete patent. So, but usually I'm in communication with the inventors about the patent.
Well, in fact, me along with my thesis advisor have filed an IDF to you, and I'll let me contact to you through email about the dates, and I just wanted to know the status about their our IDF.
Which
Maybe
one was
I'll
that?
email to you in detail, ma'am.
Oh, you'll send it to me indeed. Okay, you haven't sent me so far, right?
See, we have actually we communicated in the month of August 2019. We have submitted somewhere in September 2019.
What
Our
was
idea.
the idea?
Pardon, ma'am?
What was the idea? What was the title?
Sorry,
What's the title of the idea? Title.
Title. Okay, electrochemical synthesis of bismuth iodide thin films.
Oh, that's interesting. Oh, okay. I didn't respond to you. Let me look at it and come back to you. I don't have I have to look at my records. What happened? 1 second. I'll have to check that. Dr. Kumar? I'll come back to you on that.
Okay, ma'am.
Any other questions? Okay, so if you have any other questions or filings, you can contact me at the Salma@amrita.edu or patents@amrita.edu. Thank you. Thank you very much.
Thank you so much, Salma ma'am, for enlightening on the process. In fact, I wanted to add also, you were telling that too much noise. 2015 was we've been seeing a big increase in the trajectory, and I wanted to also add that it is also reflecting in the university. So, no doubt, all these have majorly helped us in the NAC A++ grade and also the top private university. Thank you so much. Thank you for your outstanding efforts, ma'am. Thank you.
Thank you.
Satish Babu, over to you.
Namaskar, sir. Namaskar, sir. Sir, am I audible?
Yeah. We can see you, sir.
Yes, sir. Sir, my slide is visible, no?
Yes, sir.
So thank you, Prashant sir and Shashankan sir, for inviting me to the important webinar. And thank you, Sunitha ma'am and Salma ma'am, for giving the details of patent laws and patenting procedures of our university. In fact, before I started preparing for this talk, I just asked Shashankan sir, what am I supposed to speak today? He said, just share your experience in patenting process of our university. So in the coming couple of slides, I just tried to share some of my experience and humble effort to develop some of the prototypes and finally those with international patents. So when we try to search for an idea or what can be patented or what is to be patented, we normally get this kind of a statement. The invention must demonstrate a new characteristic that is unknown in the current body of literature. So there is something there, as Sunitha ma'am and Salma ma'am said, there must be something novel, something new, so which is not appeared in the prior art already. So people, how do we understand? So in whether in publishing or in patenting or to start research, most of our research scholars start with the literature search. So based on the literature, we understand the problem and also we think about what others have done so far from the literature we understand. And we identify the gap, the research gap. Then we propose a solution for the research gap. We try to bridge the gap. And this is what the so-called funnel shaped literature search or funnel kind of procedure, funneling. And this is, I think all of us are very familiar with this procedure. And even we think, for example, in chemistry, we always say, okay, there is a chloride substituent which is already reported. Why can't we try with a bromide? Or in nano, we say it's a nano composite with copper or other type of materials. So can we substitute the copper with manganese? These kind of slighter modifications people always try to explore with this kind of. I'm not making fun of anyone, but this is also people always try. And there is another way of looking at the problem based on the actual need, actual problem which exists. So what we try to do in that case, understand the actual need or the problem which is to be solved. Then once we understand the problem correctly, we propose a solution for the problem. And also at the same time, we try to compare the existing solutions for that problem. Then we propose the final solution for the problem. This is based on our understanding on the problem and the problem which is need to be solved because there is an end user on the other side. So this is what typically our chancellor always talk about, the living lab type of experiments. So this living lab, we always think that normally done by the undergrad students. But my point is all the research should be like this type of living lab type of solving problem. Let us try to understand the actual problem and let us try to solve the problem. So But this may take more time because we are trying to solve the problem based on the requirement, rather not just based on the literature. So this obviously definitely more cumbersome in solving, and the solution also might be difficult. So just to propose on this, or the way mostly I tried solving the problem, I tried to think different as much as possible, not always. Then the second point which I want to tell you on the translational research, and thirdly on the transdisciplinary research or the multidisciplinary research, and dare to take challenging problems. So in the couple of coming slides, I will be explaining only on these 4 points. Different. I just shared some of my personal experience in doing research during my PhD days. So I was originally working with organic chemistry problems. Then slowly I turned into electrochemist because Bipin sir, you all know our biotechnology dean, he was telling me to develop glucose sensor. I also started working with glucose sensor with the typically based on the literature search, what has been happened and what I can do towards that. And I could get glucose oxidase enzyme from the market and then tried immobilizing on the electrode surface all that. But later I found there is not much charm in doing that because a lot of literature on the same thing and all the market available sensors are based on the same glucose oxidase enzyme. Then I slowly was trying to solve something which was not much explored on those days. Enzyme-free sensors. I was trying to do with enzyme-free sensors. And typically that is based on nanomaterials. So when we try to solve something which is not really existing, there might be here and there some literature, there will be a lot of questions, whether this really work. And it's very difficult to convince people around you also. But my only recommendation to all my research scholars who are sitting here, let us be very, very confident on the problem which we take and also be excited with your ideas. That definitely give you results. So here, what I tried largely was on just focusing on my ideas of developing something which is enzyme free. And because the glucose sensor market is such a huge market and which is governed by the market leaders across the globe. So trying to do something which is slightly different from that, it always arises a lot of questions around the people, and even when you submit the paper for a publication. So that's how I started my research. So the two key points which I want to tell you here is, let us be very, very confident and excited on our research problem and try to solve with a lot of conviction, because if you are not convinced on your research problem, you won't be able to convince others. So let us convince ourselves at first on with our research problem and try to convince others. Then this is what my first point on think different, and you can even intervene me at any time of the discussion. I take largely 20 to 25 minutes only, so we have time. Then the second point is on the translational research, which I am trying to say. Because normally what we do is we do an experiment, get exciting results, and immediately we look around the literature and understand this has not been published. So immediately we write a manuscript and upload. And that finished that problem and we start with a new problem. And in that process, we will be able to generate a lot of publications, because we go only up to the point where we get a good amount of good results and then publish. But here I'm trying to tell you something beyond. But you may not fetch lot many publications in this exercise, but you can be happy all the time. See here, as I just continue with my previous experience, where I tried developing the glucose sensors. Once I got excellent results, somehow I wanted to translate it into as a simple prototype, which is possible. But those days I did not have the facility what you see today. What I just tried doing was just took a plastic strip which is of similar dimension as that of the commercial glucose sensor, Then just made 3 silver lines on that with the PCB making kind of ink. You can see here, I just take my pointer. So there are 3 lines I made here. This dimension of this strip is exactly similar to that of the commercial glucose sensor strip. Then try depositing the catalyst which I used here, the same kind of catalyst I tried depositing here. Then we know here we use a silver chloride reference electrode. So I just want to bring silver chloride here just by electrochemically oxidizing the silver on my electrode in a potassium chloride solution. So I have the pseudo reference electrode ready and the working electrode ready, and tried with the samples, the laboratory samples, and then with the actual samples. I got exciting results, and this is typically a handmade one with first masked with what you say the nail polish and then wrapped with cello tape and all that, and insulation tape. That made the simple prototype which I could translate from a 3 electrodes was what you see here into a device of this kind, because I'm very sure this never reached to the market because there are 3 electrodes separate and you have solution, so you cannot. So I just want to translate that into a device of this kind. Then slowly as time progresses, you can see the time also I marked here. I was just trying to make with my students a screen printed electrode of similar kind. But here I did the screen printing by using manual screens and manual squeegee. So we could do this. And parallelly, we were able to develop a glucometer for this and tried integrating the glucose sensor and glucometer with this and tried testing. So by those times, we had substantial funding from DBT to develop these 2 devices. So you may ask me, how could I get such a huge funding those days? Just because of this. So this translation, I could convince people that because of this translation, things will work. So that resulted in substantial funding from the government, and I could develop a prototype of the glucose sensor and the glucometer. Then with further funding again from the BIRAC and the other agencies, we were able to bring sophisticated tools to print electrodes of the exact dimensions and the repeatability, reproducibility, or whatever the criteria you talk about the sensors. So we could do sensors of that kind. As you see here, the different layers which I was trying to do with manually that could do with the help of these sophisticated equipments. And also we have to integrate all the components like the electrolyte, the membrane for the fluid flow to happen, the hydrophilic membrane, all those we were able to integrate together. Then finally, with the help of the industry, we were able to develop a nice glucometer, and which is on par with the commercial glucometer. So you look at the journey, this is something like a 10 years of journey. And after the first set of publications, maybe 3-4 publications on this work, I did not have any publication. So if you are so fond of making publications, you may not reach a level of translation and productization. So this consumes so much of energy and so much of money also. But ultimately, we will be happy that we have a prototype or a product that can be tested and actually used for applications. So this was the whole dream for me when I started my research, my PhD. But during my PhD time, I could do only a prototype. But with my students and the next set of students, we were able to develop substantially onto it, build up on it, and with the help of government and industry, we were able to develop the system. So this is one example of transdisciplinary research, translational research, which I wanted to tell you. So here we have 2 areas we could bring together. One is on typically the chemistry, electrochemistry, all that, and the other one is on the microelectronics, which include the embedded programming. But then, and also which resulted in 2 United States patents. And as Sunita ma'am and Salma ma'am were explaining, once we get a patent and based on the progress we make in that area, we need to add up. So that's why we have 2 patents on the same title. So one is with our first prototype and the screen printed ones and all that. Then later we added more points onto that, and then we have one more United States patent on the non-enzymatic glucose sensor. Then just continuing with the integrating different areas into a prototype development. There I said we have two different areas. One is on the chemistry aspects, or a little bit of biology, chemistry, and then on the electronics aspect. So by 2012, we were seriously thinking about developing a device which can integrate multiple sensors onto it. Again, as I was telling, this is really based on the end user need, because we used to have constant interactions with the doctors at our AIMS hospital, and they normally said many problems which is to be solved. So here what we propose is bringing many sensors onto a single device that can be used for testing on a point of care applications. And those who are new to this, point of care means where the care is needed, there we do the diagnosis or the testing. So this is again another type of device. So when we started seriously thinking about this device, we lab on a chip device, we understand that there are multiple fields to be brought in together. One is on the biosensors, which I explained already, and another one is on the microfluidics, because there we need to bring in many sensors onto it, and we were trying to test all of them as very close to that as we do test in the lab, because in the laboratory testing we use, as I was showing you there, a beaker, electrodes, all that. In solutions we directly test, but when we fabricate a complete sensor, we do the testing on a solid state electrode. There is no fluid involved, so obviously there will be accuracy, and all that thing will be not as much as you test directly with the sample. So, but here we tried testing all of them into the liquid medium itself and trying to develop a microelectronic system for that. So you just try to, I'm not trying to frighten any one of you, just to understand the complexity of the problem. The chemistry, biochemistry, biotechnology, physics, all of them involved in the development of the sensor. And you look at the microfluidics, typically fluid mechanics, finite element modeling, computational fluid dynamics, all of them are involved. And the microelectronics, again, the digital analog electronics, embedded programming, all of them. And thinking in this side of the fabrication process or the development, you see for a sensor, typically the material selection, synthesis, characterization, all of them. Then testing it in the simulated fluid, whether it works or not. Then the fabrication of the sensor, testing with the samples, laboratory samples, real samples, a long series of process involved. And likewise, the development of microfluidics, their design, simulation, microfabrications, similar in the case with the electronics also. So here we really learned that working like on a compartment basis will not fetch things. We need to talk to the people of other discipline. We need to understand. We need to work together as a single group, so that we will be able to develop things not just in the laboratory, but it can translate and go to the at least to the clinical trials or the market trials. Since I work on the diagnostics areas, I am just confining myself with this. So similar in the case with any other area. Suppose if you try to solve an industry problem, talk to the industry or the end user who really need it to be solved. So you get better input from the people who really use it, and so that we will have better clarity on the problem, rather just looking at the literature. I'm not saying reading literature is not poor, but once we understand the problem and then we read the literature, we get a beautiful problem which is really supported by the literature. Then when we try to solve this, we understand this is how it looks like. This is a schematic diagram of this one, and madam was showing about the patent of the same thing. And here we have the sensors here and the microfluidics all ready, then that are integrated as a chip, then develop the electronic device for the testing. So here we tried testing 5 different analytes. You look at glucose, cholesterol, uric acid, bilirubin, and creatinine. And you have to give the sample normally in a clinical lab, which is really sophisticated, wait maybe 3 hours, 4 hours to get the result and do the testing. But here, this device, just by introducing a drop of fingerprint blood, you get the result. At your convenience, wherever you want to test, you can test. So this is what I really mean by translating the technology which we really do in the lab to as a device. And so here I just want to connect 2 points: translational research and transdisciplinary research that really help you to develop product or prototype. This is not just with the clinical diagnostics. This is applicable to all areas of science and technology and engineering. And with this, we have this United States patent, which recently awarded. We filed in 2018 and then recently got it awarded. Then looking at similar problems, again, based on the end user demand. Because a very serious problem is the cancer diagnosis, that too early diagnosis, because normally cancer diagnosed at a later stage, so that it's very difficult to cure. But almost all cancers are curable if we are able to detect at much early stage. So what we were trying to do, a very small, humble effort. Here we tried developing sensors. But we know most of these sensors are based on immunoassay, and immunoassay normally done by very, very trained technicians or PhD scholars. So when we develop a device for a point of care application, you can't expect trained technicians or like an experienced PhD students over anywhere. So other than a sample injection, if you give more choice to the people who use it, you cannot expect a reproducible result. So what we try developing towards this is we try to automate the entire process with the help of microfluidics, microvalves, sensors, electronics, all of them put together. Because here one more area is involved. There I said 3, and here there were 4 different areas we could merge together. And we tried developing a completely automated immunoassay for protein detection. Likewise, another one is on the bacterial detection, because bacterial detection normally done in clinical labs by culturing, and the culture-based analysis takes about at least 48 hours. And by that time, the infections will increase much more. And again, you need to give so much of antibiotics. But if we can understand the infection at an early stage, again, it's very easy to cure. Infection typically is the type of organism that infect. Typically, we say the different types of bacteria. So here also we propose a similar devices, but the sensors for all of them will be different. The electronics program, all that will be different. But what I try to emphasize here is there are multiple areas involved, multiple people involved, multiple expertise are required to solve a real-time problem. I don't want to explain too much about it because these are under the patenting process. Then by this time you might have come to a conclusion that something, if it is need to be patented, that must be really a complex system. Because I was explaining multiple areas, transdisciplinary, all that, but need not be always. There are systems which are extremely simple that can also we can take towards IP. Here I just say one example of a liver function test. Normally, this liver function test is conducted in sophisticated clinical laboratory. There it takes some 2 to 3 hours or even more to get the results, because they do normally test 3 enzymes, protein, bilirubin, all some 5 to 6 parameters they do analysis. So it takes time. And again, the cost is anyway between 800 to 1,200 kind of rupees. But here, what we proposed and developed the prototype of a device is a paper strip, a simple paper strip that can integrate multiple sensors. Here, typically is on optical sensors, a color-based detection, and that can test all these 5 analytes, because we targeted for 5 most important analytes of the LFT. And here we could see the color change for all of them just by introducing direct blood sample, because we made the mechanism to separate plasma from the blood, and then only the plasma go into the reagent site and we get the color. So this is an extremely simple device that does the job of very sophisticated testing which is done in the clinical laboratory. So need not be very complex to be different. Then just this is my last slide on a frugal innovation. Again, totally different logic of what I've been explaining so far. This was also done by one of my PhD student during the completion stage of her PhD, not as a major part of her thesis. Here, this is a simple device, excuse me, for hemoglobin detection, because we know anemia is a very severe problem typically in the rural community and typically adolescents and pregnant women. So we try to bring up a small handheld device where we can test the hemoglobin content without much of effort, just by finger prick and test with a simple device, and it can even work with a DC powered battery, because even some part of our country we cannot expect the electricity also all the time. So that type of a simple frugal innovation for anemia detection. And this, in fact, she got Gaiti award from the Vice President of India, and this is already filed for patent. So what I'm trying to tell you with this, some of my experience, need not be very complex system to be patented, or need not be very simple also, need not be only one restricting one area or the other. But the key, what I find, is the innovation. The innovation makes the work, whether it is patentable or not. So if we have innovative idea, and if we are able to think different, and if we are dare enough to again challenge the existing scenario of systems or the methodologies, then definitely our work will be, we will be able to patent our work. And it's not just done by me, it's mostly done by my students. I just represented my students here, and the tremendous help from Professor Bipin, the Dean of Biotechnology, and for most of the funding and typically the early stages of our growth in the research process. And I always thank my thesis advisor during my PhD, because he gave me a lot of freedom. He never gave me a ready-made problem to be solved. He largely gave me the freedom to think, and made me to think. That made me to translate something which we normally do in the lab to something like a prototype, or then to a device. So these great people around us, and we have beautiful students who are able to solve problems, and definitely we will be able to do things. And the funding agencies, we got substantial funding, at least 7-8 grants from Department of Biotechnology, and BIRAC substantial funding, and also with industrial help we are able to develop so much. And thank you so much. If you have any doubt on whatever I have done, I am happy to share. Thank you. Thank you, Prashant sir.
Salma ma'am?
Yes.
Yeah.
I think let Dr. Satish answer whatever questions there are first.
So, Satish, I have a doubt. You were telling, when you are into translational, transdisciplinary research, and you're into that patenting bandwagon, there is definitely a constraint with respect to publishing. But as you know, as far as we are concerned, the rankings and accreditation, a major chunk of those things depend a lot on publications, and also the impact of those publications, both quantity and quality, so as to speak. So how do you strike a balance? That's what my question is, because I understand you're also published while you were developing these technologies. So how do you strike a balance between the publishing and the patenting part?
Yes,
your
sir.
own experience, so and so.
Yes, sir. So, because as you rightly said, most of the PhD students require publication for their thesis to be submitted. So here we expect them to publish. So definitely they make publication. But what I normally practice that I can share you, because please don't get offended in my statements. It's what I do. I just say, I don't normally give any ready-made problem to any of my students. This is my first point. I never give a ready-made problem. You solve this, I write paper, or you solve, you write, nothing like that. I just give an open-ended thoughts for the students. You can solve in this particular these problems. No, never like a solution for a problem. So these, because I am very confident that students are much better than me always. So they can do better thinking, they can do better in all their aspects of research, and because obviously, as you say, the generation gap. So this is one thing. So some of them will be a very bigger idea which we multiple people together solve. But obviously, all of them will be able to pattern, because every student will strike with multiple problems, and some of them will be excellent, some of them will be average and below average, all that. So we weigh them accordingly, and then we put it for publications, because publication again mandatory, because we should not keep the students for so many years here. On an average, most of my students complete their thesis in 4 years. And one thing what I found is the ideas, the students' ideas used to be very good. We should encourage students in solving problems. Students, I really mean the PhD students, because they get substantial amount of time to solve the problems. So we definitely publish, and other flip side also, I tell you, as you said, most of my students have publication ranging from 4 or 5, but I can tell you most of them have at least one patent filed or patent in their name, US patent. So this is how we balance. So they get both the experience, typically the product development and also the basic research. And most of the time I tell the students, you just try to understand a real-time problem, then that need to be solved. Rather just look at the literature and try to solve. That's simpler and easier. But at the end, students may not learn much from that, because they only try to identify a problem and solve it. But here they try to identify a real-time problem and propose a solution for that, and try to work out the solution for the problem. So that's the strategy which normally I follow, and most of the time it worked also. Yes, sir.
Sir, I have a doubt. This is general. From morning itself, I am seeing that everybody is applying for US patent only. Why it's so, sir?
I think this question Salma ma'am can answer better.
Yes. I'll answer that. Actually, most of the patents that Satishi has mentioned, we've filed for US and Indian patents. As I said earlier, we almost always file the Indian patent first, but almost always the Indian patent takes much longer to get granted. So all the US patents that Dr. Satish showed you in his slide also have Indian patents pending, but they're not granted yet. They're getting granted, they're almost granted, but they're not granted yet. So if you remember that slide I showed earlier, the majority of our patents granted are foreign, they're US patents. I would say about 80% of the granted patents are US patents and 20% are Indian. But as I showed for the slide from, actually I can go back to that just to refresh. Wait, I don't think you can see let me just share my screen for a second. Let me go back to that slide so you can see it. Yeah, this one. So these are patents granted since 2011, but as I pointed out for 2021, I think this is going to be a change where we have more Indian patents getting granted than US or foreign. So does that answer your question? I think it's Amala Devi, right?
Madam, you can also explain
yes,
the coverage of the patent also. Probably.
Sorry?
The coverage of the patent.
You mean by technology?
No. The country wise, why we go for a US patent and why other countries? Yeah.
Well, normally we go for US because they have a very good system for reviewing and granting. The IP protection in the US is very strong, And commercially, yeah, basically those are the reasons we go for the US one. And the costs are not so bad. I mean, it's more expensive to file for US than an Indian patent, but yeah, those are some of the reasons that we go for the US patents. It has a very strong IP. The thing I do want to say is that the patent IP is only protected in the country that it's filed. So, you know, the Indian patents protect the IP in India, the US ones protect the IP in the US. Does that answer the question?
Yeah, I think pretty much. Yeah.
Yes, ma'am. Thank you.
Is Mohan Kumar, are you still there? You asked me something earlier. Mohan Kumar?
Yes, ma'am. Yes, ma'am.
Okay. Oh, yeah. Thanks. Okay. Actually, I appreciate your question. Because Satish Babu, you should stay on in case anybody else has questions for you. But I just wanted to address Mohan Kumar's question. So I looked up the patent that you were talking about, and we started filing it in 2019. And what happened was you were filing with Dr. Murali, right?
Yes,
Dr.
ma'am.
Yes. So I had asked Dr. Murali for the assignment agreements, and I didn't receive all of them. So I was waiting for, I think, your assignment agreement and maybe one other person's. I didn't get the assignment agreements. So if I don't receive the assignment agreements, I can't proceed. So
in fact, we signed it and submitted to you in the month of September 2019, ma'am.
Yeah, I looked at my files and I didn't, but can I just say for everyone, if you have a similar situation as Mohan Kumar, just follow up with me. You don't have to drop the matter, just keep following up. I have the patent office is mostly me. I manage about 80 patents at any one time on my own. So please feel free to continue emailing or calling me, okay? That's also what I wanted to say. And I'll check my files, but I don't have the email. The last email correspondence I had was in August 2019.
Yeah, August 13 and 14.
Yeah, but I
I
didn't.
you, ma'am.
Sorry?
In fact, I mailed you on August 13th, 2019.
No, that's the last record I have is when I sent you the assignment agreements. But the thing is that, please, can you send them to me now? The matter is not dead. We can still pursue it. But for everyone else on this call, if you're filing a patent and I don't respond, please call me or ping me again. Okay? Because I feel bad that this happened and I don't want it to happen again. All right? So, Mohanji, please send me those documents. Yeah?
Yeah, I'll discuss with my Dr. Murali Rangarajan sir, and I'll get back to you, ma'am, as soon as possible.
Thank you so much. Yeah, thanks. And I also checked your file. We didn't do a prior art evaluation. So we should also do that, especially because it's a couple years later, to make sure it's novel. Okay, but please email me or contact me.
Sure, ma'am. I'll do that.
Okay, thank you. Any other questions for Sadishji or myself?
I think that's it. Presentation.
Thank you, Satishji. That was a really good presentation. That was very good. I think that was inspiring for a lot of people. Thanks, Prashantji, for organizing everything.
Yeah, thank you, ma'am. I think we can close. I think the presentation was very clear, so everybody's clear. Thank you, everybody, for the participation. Thank you, Salma, ma'am. Thank you, Satish, sir, for a very lucid and practical presentation. So from the IQAC side, let's hope that we get many more patents. I thank my co-host Dr. Murali Krishna, who's also a member of the IQAC, and thank you. Have a nice day. Stay safe. Namah Shivaya.
Thank you, sir.